All right, so the next panel is AWA-Related Litigation and Other Efforts. And this one will be moderated by one of my favorite litigators ever, Justin Marceau from the University of Denver Sturm College of Law. Thank you. And also an HLS alum.
Great. So as Chris mentioned, I'm Justin Marceau from the University of Denver, and I'm very pleased to introduce this panel this morning on emerging issues and litigation under the AWA. I think these are some of the greatest lawyers and emerging lawyers in this field. I am really excited to have gotten to know some of them over the course of the last couple of days and have learned more about each of them over the last few years. It's a really amazing group. The first, I guess, two panelists that are going to speak to us kind of in the background areas of the AWA and who have tremendous experience and expertise in this are Joyce Tischler and Valerie Stanley. Valerie is an adjunct faculty in animal law at the University of Maryland and has just done a tremendous amount of work on wild horse litigation. She was a senior staff attorney for the Animal Legal Defense Fund after having founded her own firm. And then Joyce Tischler, who I'm sure everyone in the room knows at this point, she's one of the iconic figures in animal law. I have repeatedly and continue to credit her vision and the way that she wanted to work animal law into law schools as a reason that I am here today. And so I am always grateful to her and her vision for the field. Right now she's the general counsel. In addition to being the founder of Animal Legal Defense Fund, she's the general counsel of ALDF and continues to be actively involved with the operation. So it's great to have her. The second speaker will be Jenny James, who is counsel with PETA and whose litigation efforts have involved the Animal Welfare Act, among many other statutes. She's working on really the cutting edge of some of these issues involving standing and what we're going to bring into court regarding the Animal Welfare Act. And I think, even just over the last couple of days, this is a little bit off script, but people have mentioned to me, I think even among folks who are sensitive to animals, there's this sort of notion that the PETA folks are off the rails or something like that. And so in this second to last panel, I'm really happy to have Jenny here. I think she's, for those of you who are skeptical of PETA, she's a truly clear-eyed and hard-nosed lawyer, very pragmatic, and I think that will come across. And finally, we'll hear from Kathy Meyer, who I only just met this weekend, and someone that I have long looked up to. Her firm that she founded, Meyer, Glitzenstein, and Eubanks, is one of the giants in public interest law generally, and particularly in environmental and animal rights law. I'm sure most folks in the room know of their work, but the things that make me most proud to be associated with her on this panel and that give her particular gravitas in my world is that she has consistently been unafraid to take on the biggest and the worst animal abusers in the country. And it really is something that I think we should all be thankful for. It's hard, it's tireless, it's at times, I imagine, scary work. And so thank you very much to all of them. And if we could please welcome Joyce and Valerie, who are going to get us started.
Yes. Sorry. Yeah.
No, get ready. Just forward and reverse.
Forward and reverse. Okay. So just there it is. Okay. For those people in the room who are not lawyers, you've probably noticed over the past couple of days that our hand-to-eye coordination is not very good. In 1985, my organization, ALDF, was about 6 years old, and we were pretty bright-eyed and bushy-tailed, very naive in many ways. And when we saw the 1985 amendments passed, we thought, this has great potential for improvement. And in fact, the title of the amendment was Improved Standards for Laboratory Animals Act of 1985. We focused on that word, improved. And we thought what we wanted to do was to flesh out the terms of the Animal Welfare Act. It had been around for 20 years, but it had never been litigated. And we thought, oh, here we are, we're going to do that. We hoped that lawsuits would assure that the protections written into the law, especially with the amendments, would actually be delivered to these animals. So in 1986, the first thing that we did was our then New York staff attorney, Jolene Marion, who some people may remember, remember, worked with Eleanor Sealing of United Action for Animals, another name some people remember, and they prepared a response to the USDA's request for information on pain and anesthesia with reference to the 85 amendments. And the response included 141 examples of painful procedures that had been performed in U.S. laboratories on fully conscious animals, where, as far as we could tell, and I'm now channeling Larry Carbone here, anesthetics or analgesics had been withheld. These descriptions had been taken from a wide variety of scientific journals, because that's what Eleanor Sealing used to do. She'd sit in front of her computer and get into all these journals. We'll never know if anesthesia or analgesics had been withheld, but they weren't mentioned in any of the articles, and so we presumed and contended that the withholding of pain relief violated the AWA. And of course, that's as far as that report went. Having listened to Sue Leary last night, I realized that I was going to have to substantially change my talk, which I did. You have already heard the tortured history of the Animal Welfare Act and rats, mice, and birds. And as we all know, in 2002, the Act was changed to exclude rats, mice, and birds from the definition of animal. And you also heard that in 1970, Congress substantially broadened the definition of animal. This is something that when I teach, I focus on the words, the animal includes such other warm-blooded animal, comma, as the Secretary may determine is being used, comma, or is intended for use for research, testing, experimentation, and so on. In 1971, the USDA promulgated a regulation that specifically excluded rats, mice, and birds from the 1970 definitional change. But we thought, and again, we weren't really getting active until the mid-1980s, we thought that the 1971 regulation clearly violated the plain language of the 1970 amendment. So ALDF and HSUS, working together, filed a petition for rulemaking with the USDA, and when that was eventually declined, we then sued the USDA in federal district court. And the judge assigned to that case was Charles Ritchie. And in response to us, the USDA had some very colorful and logically strained arguments as to why they were not including rats, mice, and birds. And you had to give them points for creativity. At first they said Congress gave the USDA absolute discretion to interpret the meaning of the word animal. Their second argument was the phrase, as the Secretary may determine, gives the USDA discretion to choose which species to include. And my favorite, they said that the USDA had never determined that rats, mice, and birds were being used in research. Shockingly, Judge Ritchie didn't buy any of that. And in granting our motion for summary judgment, he held that the USDA's construction of the Act was arbitrary and capricious. And he began by quoting the stated purpose of the Animal Welfare Act, to ensure that animals intended for use in research or for exhibition are provided humane care and treatment. And Judge Ritchie reasoned that if the stated purpose of the Act is to ensure that animals used in research are provided humane care, inclusion of 95% of those animals would help to ensure that the purpose of the Act is met. And exclusion of that 95% would not serve the purpose. Smart cookie, that judge. To us, this lawsuit seemed like a no-brainer on the merits, but on appeal, we could not get to the merits because we lost on standing. The D.C. Court of Appeals vacated, holding that none of our 4 plaintiffs had standing. Now, for those of you who are not familiar with standing, lucky you, standing is the legal system's way to keep unpopular plaintiffs out of court. And in the mid-1980s, believe me, there was no one more unpopular than some animal rights attorney trying to protect animals in research. We were painted as mindless, overly emotional, people haters, and anti-science. 8 years later, as Sue Leary told you, Alternatives Research and Development Foundation brought a very similar case. Their plaintiff did have standing, and the USDA agreed to promulgate regulations. And then, of course, the Helms Amendment eliminated rats, mice, and birds from the law. It was quite breathtaking, quite breathtaking. I have often felt failed miserably, and in failing, we were powerless to protect those animals, and it's on us, all right? In the mid-1980s, the research community and animal activists were literally at war with each other. There was no willingness to engage in reasoned discussion. The animal activists were having mass demonstrations, civil disobedience. The media would ask the two sides to debate, and both sides would give them a great show. They would have high-pitched yelling at each other, name-calling, posturing, and to my mind, these sorts of very simplistic debates benefited the researchers far more than it benefited us, because if you can get the debate down to that rat or your child, guess who wins? Show over. They win. Rats screwed. But what does it say about us as a society when we, on the one hand, accept as necessary that we can use the bodies of others to protect our own well-being, our own lives, and we assuage our feelings of guilt, and I think they're there, by promising humane care and treatment, and then it's never delivered, okay? Are we liars? I'm thankful, after all these years, to the planners of this conference for giving us the opportunity to revisit what are very painful issues. My sense is that both communities, science and animal protection, animal rights, have matured. At least I hope so, Konahara. And as we're bringing this conference to a close this morning, I see the possibility that now, unlike in the 1980s, scientists and animal protectionists can engage in reasoned discussions. We can treat each other respectfully, no more name-calling. We can acknowledge that while we may disagree on some, perhaps many points, we are not as far apart as it once seemed. There are common interests, and personally, I would welcome such conversations. I'm not saying it's going to be easy, but worthwhile conversations never are, and it starts by reaching out and talking. Thank you.
I'm going to be talking about the 1985 amendments in terms of the provision to have USDA establish standards for a physical environment that would be adequate to promote the psychological well-being of primates. This is the this is some of the preamble, and I think it speaks to what was discussed last night as to, is the Animal Welfare Act, was it passed, and is its purpose to really care for animals, or is it more to make us feel better about using them? And I think this last provision here sort of speaks to it. And when I reread it last night, I was thinking, well, maybe this is really the Animal Make Us Feel Better Act. And unfortunately, that's a grave concern. Anyway, the 1985 amendments were passed, obviously, in 1985. They were to take effect 1 year later. But however, in 1988, USDA had still not promulgated any regulations to implement the provisions. Using a provision of the Administrative Procedure Act, which allows one to sue for agency action that is unreasonably delayed, we brought suit in federal court, and we said to the court, it's now 3 years later, where are these proposed regulations? It was really like one of the high points of my career, because that morning at our first status call, the USDA lawyers announced that that very morning in the Federal Register, there were the proposed regulations. And so the judge said to us, well, if she files a motion for attorney's fees, you're going to be hard-pressed for me not to grant it. So in one day, we got what we wanted, and the government was going to pay us, and it was a really wonderful time. Unfortunately, that began the regulatory struggle. And I went to a conference at Harvard Law School, not at the law school yet, but just at Harvard, to talk about what was primates' psychological well-being. And believe it or not, there were so many people there who didn't believe that primates had psyches. There were some that had seen primates in distress, and they chided their colleagues for not understanding this and not believing this. So anyway, that was one of the first public efforts to actually try to figure out what could we do for primates, what could we do to improve their psychological well-being. Okay, so at that point, that concept was at the ridicule stage. And then it graduated to the discussion stage, and now it was at the acceptance stage. However, the problem was in how to implement it. And that was the beginning of another big battle that we had. The primate regulations that USDA initially issued were very good. In fact, they were too good. They required larger cages. They required social housing. They were really what we were dreaming of. And unfortunately, this galvanized the industry to fight against them. And they said, we can't have this utopia for primates in labs because there are too many types of primates, there are too many sizes of facilities, and it would all cost too much. And so what they did was they got USDA to believe that since they were the primate holders and they had all this experience housing primates, that they were really the experts, and that USDA should leave the working out all the details to the facilities that really had the most experience with them, should leave it to the experts. And, you know, we sort of said to ourselves, wait a minute, USDA is going to leave the setting of standards to the very entities who say that primates don't have psyches, that primates are doing fine and everything is just hunky-dory. We saw a huge disconnect there. I had mentioned that the initial regulations for proposed regulations actually was going to change what's on the left to what's on the right. And I want to say that USDA was, by the Animal Welfare Act, required to consult with Health and Human Services because HHS had the Guide for the Care and Use of Laboratory Animals. And that was what governed all of the research facilities that got federal grants from NIH. But where did these horrible, small, tiny, cramped cages come from? They actually came from the ILAR Guide, the first guide for the care and use of laboratory animals in 1961. And in 1961, the cage sizes started being put into concrete because they were the cage sizes that were being used. So what we have and what we've been trying to fight against was what was the status quo back in 1961. Okay, so I'll hurry along here. All right. Our first lawsuit, you have to remember when the regulations were finalized, this was 1991. So we had to figure out what kind of plaintiffs we could have to bring to challenge the final regulations. We were very leery of bringing people who were upset about primates bringing them into court, because frankly, we didn't believe that the court would accept such plaintiffs. We just didn't think that the time was right, that we had to have more of a traditional approach to standing. We had a person in there who had suffered an economic harm. We thought economic harm, surely the court would buy that. That was something they were comfortable with. We had a member of an IACUC as a plaintiff who claimed that because the regulations didn't have standards, he was not able to perform the annual inspection because there was just nothing was required. We had a researcher, Dr. Roger Fouts, who had the same complaint. Actually, believe it or not, the court found that none of our plaintiffs had standing. But we had Judge Mikva's concurrence, and he said basically that if the plaintiffs had brought in a person who was concerned about animal welfare, that person surely would have had standing. So when we got that opinion, and then armed with that sort of guidance, and then Judge Williams' dissent in the birds, rats, and mice case, we said we've got to come up with plaintiffs who are really speaking about what we were scared to speak about, because we were figuring that we would just be ridiculed. And so I went down to PETA, and PETA graciously allowed me to look through all of their files. Oh boy. PETA graciously allowed me to look through all of their files about people who had been to zoos, et cetera, and complained about what they saw. And we found a wonderful plaintiff, Mark Chernoff, who had gone to the Long Island Game Farm and seen primates in horrible conditions. Anyway, I just want to tell you the first time when we sued using that theory, we still lost. We had a very hostile opinion from a judge who started his opinion this way. This appeal is but the latest chapter in the ongoing saga of the Animal Legal Defense Fund's efforts to enlist the courts in its campaign to influence USDA's administration of the Animal Welfare Act. Now think about that. If this is a Fortune 500 company bringing suit, if this is a utility, if this is an oil and gas company bringing suit for an agency's continued recalcitrance to do what it was supposed to do, would the court say this is an ongoing saga? No, it wouldn't. It would just be, business as usual, and this is what we're used to. But this is a bunch of animal people coming in here and presenting things that we would rather not think of. So in any event, Kathy Meyer filed a petition for rehearing, and it was granted. We had Judge Wall had issued a dissenting opinion, which said that she felt Judge Santel was far off the mark in terms of standing. And eventually, we were able to get standing. Unfortunately, and I do want to just touch on one other thing real quickly. Finally, USDA, after administering the act for, I think it was about 9 years, determined that, this is the eye-hand coordination. It's not good. But USDA had determined that the plan regulations were completely inadequate. USDA inspectors did not know how to inspect to see if the research facility had a plan, whether the plan was promoting psychological well-being, and the facilities did not know how to write a plan for psychological well-being. All of the things that we had told them would be the problems in the beginning, they finally had to acknowledge. So in any event, Kathy will tell us about our win in the ALDF versus Glickman.
But first, thanks, Delsey. Hand-on cords. Oh, she said Kathy. Tricked me.
Okay, great. Thank you. Okay, so actually I'm going to continue on with this case, which is Glickman. But really, I want to talk about the fact that this weekend, the AWA has taken really quite a beating, and I want to shift our focus and kind of beat up on the judiciary for a little bit. The judiciary is the branch of government that's supposed to provide a check on executive branch when they're not really fulfilling congressional intent for whatever reason. But as litigators, we face so many hurdles and pitfalls seeking judicial review that really meaningful relief is so far pretty much lacking. The biggest one, as you've heard from pretty much every panel, is standing, and I was the person designated to talk about standing, so I'll get into it a little bit deeper. But those of you who are lawyers know it far too well, and so I'm just going to give a brief overview for the rest of you. So I like Joyce's definition of standing better than my own. I think standing is just a way to get your foot into the courtroom door, but her definition that it's a way to keep unpopular plaintiffs out is an interesting interpretation. So if you're trying to sue in federal court, you have to satisfy what's called Article III standing. That's from the Constitution. And really the language in the Constitution is just that federal judges can only hear live cases and controversies, but that's been interpreted to have these three standards: an injury in fact, causation, and redressability. And in the case that Valerie was talking about, Mark Jernov, the plaintiff who had gone to see the isolated primates at the game farm, he had all of these. His injury in fact was that he had seen and suffered from seeing these primates in this terrible condition. Your injury has to be cognizable, it cannot be speculative, and it pretty much has to be ongoing. For causation, we often have a problem there because really who was causing those primates to suffer was the game farm. And so sometimes there's a little bit of attenuation problem that we have there. But in this case, the game farm couldn't have been doing that if the USDA's regulations had been up to snuff, and so the court found causation there. And then redressability just means that a favorable ruling has to at least have some potential to relieve some amount of the injury that the plaintiff has suffered, and that's kind of why the injury has to be ongoing, because if the plaintiffs that if the primates that Mark Jernov had seen were all dead, then his harm was not redressable. So in addition to satisfying Article III standing, statutes sometimes impose their own, and a very common one, and this one's from the Administrative Procedure Act, which, as Valerie explained, is the way we get into court to talk about the Animal Welfare Act, requires also that you fall under the zone of interest. And that's an interesting challenge here, too. The Animal Welfare Act is supposed to protect the animals, so how do humans get standing? And that's a lot of how we're kicked out of court. But in this case, because the Animal Welfare Act is in part to facilitate the viewing of animals for education or entertainment, then Mark Jernov was protected or had standing. But in contrast, some of the earlier standing problems that ALDF had in the earlier suit, they were saying that they were harmed because they were not, the USDA was not collecting the primate environment enhancement plans, and so if the USDA had collected them, they would have been public, ALDF could have reviewed them. But the Animal Welfare Act isn't about transparency, and so they didn't fall within the zone of interest of the statute, and that's why they didn't have standing in that case. So you can imagine it's kind of difficult to find people like Mark Jernov, even within PETA's rosters. It's not everybody's harmed in this way. And it's always good to come to court with lots of standing theories. So one of them might stick, because once you have one, the case can proceed. But so if any of you are emotionally attached to any animals in terrible conditions that you might want to see addressed, just let us know. We won't do anything about that. So it's good to know that organizations themselves can also go in, and they accomplish this kind of two different ways. They can sue on behalf of a member who is harmed in a way sort of like Jernov, and that's representational standing. Or the one we like to use even more is suing on their own behalf for their own injuries. It's organizational standing, but we really call it haven standing. Since we're really short on time, and this is probably only interesting to lawyers, we can get into the nitty-gritty and questions and answers if you want. But it boils down to this. You can have haven standing if your organization's mission is frustrated, and if the organization is forced to divert resources to combat this wrongful behavior that frustrates their mission. Glickman 1 is what we call the case that we were talking about where Mark Chernoff won standing. And if I got everything right, and ladies, feel free to correct me because you guys were there and I was not, there was a win at the district court level, and that was great. But on appeal, it was the circuit court that raised the issue of standing, and that's another reason why standing is such a terrible hurdle for us. It can be raised at any time, and courts can and do raise it sua sponte. So you already won on the merits, and now you lost on standing. So that happened in the DC Circuit Court in 1997, but on a rehearing en banc, they did find that Mark Chernoff had standing. So that's why we love this case and love to cite it. But I believe that in Glickman 2, we ended up losing on the merits in 2000, and that was because at issue here was whether or not the USDA had fulfilled its statutory duty. Its duty was to promulgate regulations for the well-being of primates and their psychological well-being. And there the court found that the agency had met its burden just because there were some of those engineering standards. Remember yesterday we talked about engineering versus performance standards. So the fact that there were some engineering standards, such as minimum cage size, that were enforceable, that counts. The USDA had promulgated regs. That's what they were told to do. And so we still lost Glickman. And that was tough. So that brings me to one of my other least favorite hurdles or pitfalls. This is really more of a pitfall. It's Chevron deference, and it comes up in basically every case filed against an administrative agency. And it's basically this. Courts don't want to be in the business of second-guessing agencies. Agencies have expertise. They're the ones charged with balancing these delicate policy questions. They have limited resources. And so courts want to show them deference anyway. And in Chevron deference, it works two ways. The first step is, did Congress speak clearly? If Congress spoke clearly on the question at issue, you're done. The court identifies the mandate and decides whether the agency met it. But if there's any ambiguity, you move on to step two. You don't really like to go to step two. That's where the court just asks if the agency's interpretation of this ambiguous duty was reasonable. And that bar is really pretty low because the court could agree with the plaintiff that there's a better way to interpret it. There's a much more satisfying way, but as long as the agency made a reasoned choice, they pretty much prevail. So we do not love Chevron deference. Then there's enforcement discretion, which comes from Heckler v. Cheney, and that's basically, that keeps us from bringing a fair number of cases. And Heckler, what the court was doing was really distinguishing between when an agency takes affirmative action, in which case judicial review is presumptively there. The Administrative Procedure Act says, when the agency does something to you, you can ask for review. But when the agency doesn't take an action, it's sort of presumptively unreviewable. And in part, that's because in the language of the APA, it says the courts can't review a matter that's committed to agency discretion by law. And so again, it gets back to kind of that Chevron, is there a clear requirement? If there's not, there's no law to apply. And then courts don't want to hear it. But it prevents challenges to individual enforcement decisions, but it's not a total bar to what we do to seeking judicial review because we have footnote 4. And in footnote 4, the court said, they could consider some agency inaction, particularly if the agency didn't take action because it thought it didn't have jurisdiction, because that's not enforcement discretion. That's just the agency not understanding the scope of its power. And then also under footnote 4, the courts can step in if the agency consciously and expressly adopted a general policy so extreme it amounts to an abdication of statutory responsibilities. I mean, as much as we've been beating up on the AWA and the OCA, that's tough, abdication of duty, but we tried it. PETA tried it in the failure to regulate birds. In the birds case, PETA was suing because, similar to the primate regs, Congress had made clear, as we've all talked about, that birds that weren't bred for use in research were and should be covered under the AWA, but they weren't being regulated. The facilities that had them weren't licensed. If you were finding terrible conditions in exhibitors, they weren't being written up. And so the agency had said, sure, we're going to regulate birds. We'll get around to it when we've got bird-specific regulations. We really need those. And so PETA said, well, let's go to court. Can we please have those regulations? And in the meanwhile, can you please enforce just these basic regulations. The basic regulations are food, water, shelter, vet care. I mean, really radical stuff is what we were looking for here. But the district court in 2014 found that there wasn't a specific enough policy. We had tons of statements from the agency that said, you know, we would FOIA, and they would say, well, we don't have inspection reports on that because we don't regulate birds. We would have the agency saying, we don't regulate birds. We had the agency saying, we're going to regulate birds when we get around to those regulations we haven't made. But it was not sufficient enough. And so as for the promulgation of the specific regulations, the court just found that because the agency only has to promulgate regulations as it deems necessary, this wasn't a specific case like with the dog exercise and the primate well-being. There was no specific language from the statute. So they just said, you know, they haven't deemed it necessary yet. So don't bother us with that. When the case went before the circuit court in 2015, Peter was really then only focusing just on the general regs. We're like, come on, let's just get back to food, water, shelter. It's not that bad. But they still lost for just a slightly different reason, and that was just that the court found that the USDA didn't have a clear duty to regulate birds before these bird-specific regulations were out. Like basically, they gave them a pass on having this interim time of no regulation, even though it had been, you know, a decade. So the final cases, and the ones that I really want to talk about, are the ones that involve the AWA's licensing regime. And Carney Ann sort of teed this up for us. I think we've all heard that exhibitors, dealers, breeders, they need to hold a license to engage in covered activity. The USDA inspects them from time to time, and if they're really bad, they might go after them and try to get suspensions, fines, or even a revocation. And then licensees must apply for renewal every year. But if they fail to apply on time, their license will be automatically terminated. And note that all of these cases are taking place in the roadside zoos because, as Alka said yesterday, labs aren't licensed, they're registered, and registrations cannot be revoked. So we just can't even touch them. So the first case I want to talk about doesn't even have to do with the renewal. It was just that this zoo, the Louisiana Purchase Garden Zoo, let its license lapse. And so it needed to demonstrate compliance before it could have a license reissued. We knew that it was not able to demonstrate compliance. We knew it was operating without a license for 4 months all summer. We knew that it was isolating primates, including this heartbreaking agile human that I later learned was named Kiki, and this picture was taken by Delcy Winters, who had to go and document all of the terrible things that were happening at the zoo that should not have been open. And so and they also had like facility problems, like their fence was not tall enough, like really, really obvious black and white stuff. So I was so excited, I had great law, I had great facts, everybody agrees you have to demonstrate compliance, and I still lost. And that's because agencies enjoy a presumption of regularity. And in this case, there was an inspection report that happened before the license was issued that said no non-compliant items were found. And so all of this evidence that I brought to court was not enough to rebut that presumption that the agency had done his job and that inspector had looked all around and no non-compliant items were found. So apparently the zoo was not open that day, but was open every other day we went for 4 months. Not sure. So the rubber stamping cases, though, are the really interesting ones. And it did start with Ben the Bear. So Carney Ann had talked about the state law case that freed Ben the Bear. The companion case, the Animal Welfare Act case, was over the renewal of this terrible facility's license. And so we've talked about that, the agency itself calls this rubber stamping. And this was the first time, really, to my knowledge, that we were challenging it in court. And we ended up losing there on mootness, and that's in part because we got Ben the Bear out, and that was one of the chief complaints, one of the chief harms, but also because the agency ended up taking away John Buss's license, but just suspended, but required them to demonstrate compliance again before they ever got it back. And so basically we got the relief we were seeking, sort of, but we didn't get the great ruling that we wanted. And we'd gotten some really good language on motion to dismiss early, so we were really hopeful. We're like, rubber stamping, we're going to get it. So then we went after Lolita. You've heard about Lolita, the tiny tank. It's totally non-compliant. This is math. This is just black and white. And so we also sued over the renewal of Miami Seaquarium's license. And there, the fight was really over the language of issue. The statute says that no license may issue without a demonstration of compliance. And the agency said, well, a license is renewed, that's not issued. And we said, well, you're issuing a renewal license. And so it was this silly fight over words, but what it ended up being was the court said, you know, the statute's actually kind of silent on renewals. It doesn't require renewals one way or the other, and so the agency gets to fill that gap. And when the case went up to the 11th Circuit on appeal, we also got some really bad language about due process, and they said that, you know, if you have to go through all this process to revoke an exhibitor's license, then you should have to do that to terminate it too automatically, which is really just wrong, because revocation is permanent, termination you can reapply, and also somebody whose license is terminated does have process. They can sue under the APA in the same way that we do. And so that's tough, and that language just keeps coming back to haunt us, because we have this other case currently on appeal before the 4th Circuit. It's basically John Buss all over again, but with 5 different exhibitors, so we can't be mooted, which is great, because one of the exhibitors did get their license revoked, Mobile Zoo, yeah. And so we're hoping there that the 4th Circuit will get right what the 11th Circuit got wrong, and our brief was written by Kathy Meyer. We have amicus briefs from Delcy Winters and Anna Frostig, so this is our best chance. We're going to try to really get the rubber stamping regime gone. And then ALDF also has a similar case on appeal before DC Circuit over Cricket Hollow Zoo, which you heard about from Delcy. And so what pitfalls lie ahead? Only time will tell, but hopefully one of these days we'll walk away with a high score.
Hello, everybody. Thank you for inviting me to this conference. I want to just say a couple things about what my panelists have said. I mean, after listening to Jenny, and she talks fast. I had the pleasure of doing a case with her recently and mooting her for an argument, and I was like, you have got to slow down. I can't talk that fast. She got a lot in, though. But after listening to her, you have to appreciate how all the cards are stacked against us and how wonderful we all really are, that we continue to do this work year after year after year after year. It's not just me, but many other people out there. So that was one thing I wanted to say. And I also wanted to say something about Valerie. I remember a very touching moment when Judge Ritchie, who was a wonderful judge appointed by Richard Nixon, which we now refer to as the good old days. That's how bad things are now. Judge Ritchie leaned over the podium and said to her, "You are on the side of the angels." Remember that? Yeah, it's wonderful, wonderful. Judge Ritchie, may he rest in peace. Well, all those angels up there. Anyway, I'm cutting into my time, so I'm going to probably have to start talking. So my title of my presentation is Contemplating a Citizen Suit Provision for the Animal Welfare Act. There I am. Apologies to Rodin. Kind of looks like me sometimes. And we have been contemplating a citizen suit provision for a long time. You won't be shocked to hear. Because, of course, despite the laudable goals of the Animal Welfare Act, and you've heard about one of its main purposes is, quote, to ensure that animals intended for use in research facilities or for exhibition purposes or for use as pets are provided humane care and treatment. That is the congressional statement. That's the purpose of the statute in the very first section of the Animal Welfare Act. Despite that laudable goal, as you've heard over the last couple days, the Act has fallen very short of accomplishing that very important goal. And one very glaring reason for that is that unlike most of the environmental laws and other laws out there, there is no citizen suit provision in the Animal Welfare Act. And what that means is the only entity that can enforce the Animal Welfare Act is the United States Department of Agriculture. And unfortunately, the USDA, as you've also heard over the last couple of days, is notorious for not aggressively enforcing the statute. You don't have to take our word for it, and other people have mentioned some of these reports, but starting back in the early 1990s, the Inspector General of the United States Department of Agriculture itself has written report after report basically explaining that this agency is not aggressively enforcing the statute. I put a couple of them up here. I don't know if I got them all in there, but some of the more recent OIG reports, you can see where they say, you know, the Animal Care's Eastern Region is not aggressively pursuing enforcement actions. They've been saying this, you know, for years and years and years. They've been saying that the agency, after examining their enforcement records, they're just not doing it. So here you have a statute with a laudable goal to ensure humane care and treatment of animals, but the only entity that can enforce it is just basically not enforcing it. Now, somebody asked yesterday, I think it was David Favors, like, what's that all about? What's going on there? And I think there was a pretty big consensus that it's, you know, politics, power, money, and I would add to that the revolving door, which we see all the time. We see, for example, in the Ringling Brothers case, after the whole case was over, and after years of battling with the USDA to do something about Ringling Brothers' treatment of Asian elephants, the general counsel of the agency, Kenneth Vail, became the new head of animal care for Feld Entertainment. And that's not an isolated incident. That's happened over and over and over during the years. So I would submit that that has something to do with it, too. If you're a bureaucrat, you've been working for an agency for a long time, and you're looking to your future, and you want to get a nice, cushy job, you might not be doing the work of, trying to curry favor with Valerie Stanley, but you might be more interested in being more receptive to the arguments of facilities that you might want to go work for. So what we have found is that it's so frustrating, because the rare enforcement cases that are brought, and there have been some allusions to this as well, are usually brought after we, the community here, we bring a case. We bring a case against the USDA for for its rubber stamping of renewal licenses or issuing a bad standard or whatever, and that's when the USDA jumps into action. And why do they do that? Well, they do that to moot out our case. So that's when they bring an enforcement action. This has happened time and time again, where only because we brought a case on behalf of some clients, or Delcy brought a case, or someone else, the USDA decides to start aggressively enforcing the statute. Oh, you heard, Ben the Bear. That's what mooted out the Ray versus Vilsack case, is when they went in there and shut down the facility, and we were happy about that, but part of the reason they did it was to moot out our case, so that we couldn't get a ruling that their practice and policy of every single year renewing the licenses of exhibitors who could not show that they were in compliance with the statute, and in fact, where the record showed that they were operating in flagrant violation of the statute, was unlawful. And that's the ruling that Jenny was just referring to, which that issue is now pending in both the Fourth Circuit and the DC Circuit. So hopefully we'll get a more favorable ruling on that than we did in the 11th Circuit with the Lolita case. In any event, when I say the USDA is not enforcing the statute, I by no means am impugning the integrity or the fervor of the people on the ground, the inspectors, the people out in the field. I'm talking about the people at the top. These are ultimate enforcement decisions, policy decisions that are made at the top. So this is, I just Googled, law enforcement sleeping or something, and it's a metaphor. It's a metaphor for USDA sleeping on the job here. So anyway, it's pretty obvious that we're not going to really get or continue to get or ever get aggressive enforcement by the USDA of the Animal Welfare Act. And so that cries out for the need for a citizen suit provision. And I have a list of examples, the list goes on, of environmental statutes that have citizen suit provisions. The Endangered Species Act is one we use often, the Clean Water Act, Clean Air Act, et cetera. Somebody talked about TSCA the other day. And these are were fairly routine. And if you look, I put the date the statute was enacted, and that tells you a lot. And you'll see a lot of them. 1973, Richard Nixon signed that one into law. Who would ever thought I'd be praising him twice in the same speech? But, you know, as I say, those were the good old days. But these are provisions which basically allow citizens to bring, they're called private attorney generals. Congress recognized agencies don't always have the resources, the capacity to fully enforce these very important, what were considered to be very important statutes when they were passed. And therefore, they provided for citizen suit provisions, which allow citizens, albeit those who have Article III standing, which is, as you heard, is always a hurdle, to go into court and bring a lawsuit directly against the violator of the statute. And those are obviously extremely important provisions and statutes because they allow for much more enforcement than otherwise would occur. Now, it's pretty clear, and I actually should change the name of my topic from contemplating citizen suit for the Animal Welfare Act to we desperately need a citizen suit provision in the Animal Welfare Act. So I've just here, by administrative fiat, I've just changed the title of my speech. It's really going to be the only way to ensure that animals are adequately protected under that statute. And as someone mentioned yesterday, there's no shortage of information available, particularly with respect to exhibitions. It's, you know, they have to, the inspection reports are available on the internet. You can see with your own eyes what's going on. So there's no real impediment to gathering the information to show that an entity is in violation of a particular standard. And so I think it's pretty clear that if we had a citizen suit provision, and we had people with Article III standing, which I'm going to get to in a minute, this would be an effective way to enforce this statute. And it's something that we have really been advocating for many, many years. Now, standing is going to be an important part of this. And having a cause of action is great. That's one step. You need a cause of action. But having a cause of action isn't all you need. You have to have Article III standing if you want to bring a case against someone who has allegedly violated a federal law. So it's pretty clear in Bennett versus Speer, which is a case under the Endangered Species Act, which was decided in 1997, the court held that the citizen suit provision of the ESA was so broad that it completely eliminated the zone of interest test that Jenny was referring to. So that prudential consideration is taken care of completely if you have a broad citizen suit provision. So then you're left with the other requirements of Article III standing, injury in fact, causation, and redressability. And it's also pretty clear, I think, at this point, I think scholars agree, and even courts agree, some courts agree, that Congress can create a right that someone is entitled to. And then the deprivation of that right creates the necessary injury in fact that is needed for standing purposes. One case that I would draw your attention to that made that very clear is the Cetacean Community versus Bush case, 386 F. 3rd, 1169, 9th Circuit, 2004. And in that case, which was brought by Lanny Sinkin to address the problem with sonar, use of sonar and its effect on cetaceans, unfortunately, there were no human plaintiffs that had standing, and he was trying to establish that the animals themselves had standing, and the court said, no, that doesn't work. But went on to say that, you know, if Congress creates a right by statute that someone is entitled to, the deprivation of that right would allow that individual, or arguably that animal, to then have Article III standing. And just to give you an example in a different context that you might all understand, it's very well established that there is something called informational injury. So you probably all know about the Freedom of Information Act. Everyone has a right to request access to government records. If your request is denied, you have standing to go to court and bring a lawsuit challenging that decision. And that kind of standing, you don't have to show anything else other than you asked for the information, it wasn't provided to you. That's the end of the inquiry. And that kind of informational injury was well established as enough for Article III purposes in a Supreme Court case argued by my husband and partner, Eric Lichtenstein. I'll just mention him because he's not here. Public Citizen versus Department of Justice, which is at 491 U.S. 440, 1989, and has also been established in the FEC versus Aikens case, where the issue was the right to have access to reports that political committees regulated by the FEC were required to send into the agency. We've been successful in using that informational injury argument under the ESA with respect to some canned hunting cases that we brought with HSUS and others. And we argued that the deprivation of the information that is required under Section 10 of the ESA in order to get a permit to engage in otherwise illegal activities is a basis for standing if you're deprived of the information that the Fish and Wildlife Service is required to provide. So it's pretty easy that the Animal Welfare Act, in addition to crafting a citizen suit provision, and I have one, I'm going to get to it in a minute, my proposal. It could also, you could easily, well, leaving the lobbying and all of that issue aside, which I'll also try to get to, theoretically, it would be fairly easy to craft some amendment to the Animal Welfare Act that would give everyone informational injury standing. For example, somebody mentioned, I think yesterday, these plans for the psychological well-being of primates that are required by, under the provision from the 1985 amendments, when, oh, I have to stop. Oh, I can't do that. Sorry. I'll go fast. Now I don't remember where I was. Oh, the plans that have to be sent in. When the USDA issued that regulation, it specifically said, don't send them into the agency. We don't want to have them here. Keep them at the plant. Well, why did they do that? Because they didn't want anybody to be able to get access to them under FOIA. So you could amend the Animal Welfare Act and say the plans that are required to promote psychological well-being must be submitted to the agency, and then FOIA would kick in. So there's an example of a way to get some standing. So let me just, another thing we have to have in a citizen supervision, in addition to an injury that would give us Article III standing, is a good attorney's fees provision, because if you don't have the money to bring these cases, you're out of luck, because especially when you're up against a well-heeled opponent, they're very, very expensive. So my proposal would be, I think it's my next slide. Nope. This is why you have to have standing. You're locked out. Courthouse door. Oh, in Pennsylvania, and this is a provision that we use to stop the pigeon shoot, they allow this is under the Animal Cruelty Act in Pennsylvania, any agent or of any society or association of a humane society, basically, can bring a case, has standing, this is the actual language, to request a civil injunction. So Pennsylvania is a good model, and I think if you take Pennsylvania's model and you marry it with the ESA citizen provision, and you stick in a really good attorney's fees provision, you get my proposed citizen suit provision, which I won't read to you, but it's basically an amalgam of those ideas. So we need a strategy. We need a strategy. We have some impediments. These are the impediments. There are a couple of impediments there. And we need a strategy. You are over there, and you've got to get to that. And so what I propose is that we need to literally get in a room. We need to get the lobbyists, the litigators, the organizers, the PR people, as Ron Kagan said, very important, media, the funders in a room together, and we need to map out a strategy because protection of animals is not a partisan issue. Everyone has a story. Dean Minow told her story about her science fair project yesterday. Everyone has a story like that, and we've got the videos and the photographs and the stories. And we need to get those stories out to the world at large, to the Congress people who will be making these decisions, and turn them around, because I think, as Bernie Rollins said, I wrote it down, courage and compassion transcend politics. And I think that's absolutely right. So we've got the compassion, we've got the evidence, we've just got to have the courage to do it. And so Delcy yesterday said that if she had a magic wand, that's what she would do. So, here you go. Thank you very much.
All right, well, folks are walking around with cards, and so if you have questions, please write them down as we did yesterday, and I will try to get through as many as I can. One question that I wanted to start the group with, that in this period of sort of reflecting back and looking forward on an important piece of legislation in the movement, something that hadn't occurred to me until Joyce was speaking, but that I think is relevant to thinking about this context where we are now and that many of us are complaining about, is Joyce said something to the effect of, we actually did more harm than good at an early stage in this process, that the movement did itself a disservice, I think, by the way we were acting. I think that there was, she cited to sort of screaming and name calling and this sort of thing. And my question for the panelists or those who are interested in addressing it is whether these simplistic debates, as Joyce called them, and shrill tones and tying oneself to the door, is there any room for this in the movement? Is civil disobedience always a bad thing? Should civility always be valued? Should we all behave like lawyers? Should we? I mean, not that lawyers behave well. I guess that's it. But should we try to be elevated above the fray? This comes to my attention because in the last month, a number of constitutional law scholars have been blogging about and flagging past literature on this topic of civil disobedience in a constitutional democracy and the role that it plays. And I'm just interested in what the panel thinks, because I thought Joyce's point was very astute. But what is the role of civility in a movement that is still outside of the mainstream? And is there a room for some groups or some people to call names, or does it hurt everyone? And should we avoid that at all costs and discourage people from that kind of civil disobedience that is famous in other movements?
I'll start because, yes, I did mention that, but I do think movements have stages. And that was the stage that we were at that time. And I think we needed to go through that stage. We're now at a stage where we are seeing greater professionalism in the animal protection movement. I don't think we could have changed what was happening then. It was what was, and in some ways indirectly led to where we are today. So I don't think we were making the wrong moves. We were making the moves that seemed obvious at that time. And we were, what I regret in some ways, but I think it's also part of how movements work, is that the loudest and most radical voices on both sides were the only voices that were being heard. And the more measured tones got lost in the fracas.
I don't ever hope to see a day when we don't use civil disobedience. But I also think that, if we are about being kind to others and being considerate of others, I think there's a problem with being violent to others. I can certainly understand where that comes from, because I can tell you over all the years that I worked in animal law, have to deal with my own sense of anger. And how you channel that anger is very important, but I don't think that we should be channeling that anger into direct violence against other people. So I think that's important. But no, I think that protests are absolutely necessary. The other thing is, too, is that, groups have to consider what will get media attention. And media attention can come from rappelling off of tall buildings with banners and everything else like that. And they have to be aware of that. So those are my views.
Repeat person.
Yeah, I feel obligated to address the fact that, I think there's room for both. I don't think they're mutually exclusive. I think that some groups that maybe take a more polar position do so because these things are terrible. And by talking about the terrible things in black and white terms, it at least introduces the idea. And if it does get the media attention, as Ron Kagan said, maybe that's what works, or it gets people thinking about it later. But we also need groups who can build bridges and get the incremental gains as well. So I think we all have a role in creating advances.
I agree with all that.
Next time we start at that end.
A question from the audience that is sort of, there's at least a perception and a reality that I guess that the incoming president is fond of litigation, or has been fond, at least in his private life, and has expressed skepticism of federal agencies. Do any of you think that this suggests or maybe portends the likelihood of a citizen supervision, right? That it would be a check on the agency, that it would, this sort of thing. And then my addition to that would just be, if a citizen suit provision was incorporated, is there a realistic problem, the floodgate problem, right? Are we going to be consumed with litigation from PETA and ALDF and all these cases that they couldn't bring before because we just heard about, and now there's this massive run of cases, or is that not likely to be the case, or what's the limit there?
Well, I think, a floodgate, there's something wrong with the floodgate. There's a lot to do out there. There's a huge war on wildlife and animals going on, so there's no shortage of work that needs to be done. I mean, obviously, cases with merit, and there are a lot, as you heard, there are a lot of barriers to bringing these cases, and you have to, get through years and years of motions to dismiss before you ever get to the merits, if you ever get to the merits. And then even sometimes you win standing, but you win to lose. As you heard, in the Glickman case, we won to lose. In the Birds case, they won standing, had standing to lose. So it's not, I don't think we have to worry about a floodgate, because I think everything, there's a lot to do. The more legitimate cases that are brought, the better. I like what Kathy Hessler said yesterday about Trump. He's malleable. I think that's the best, most charitable adjective we have for him today, my personal opinion. And he seems to be the kind of guy who, if you took him in a room and you showed him some videos and told him some experiences, he might come around a little bit. Maybe not, because I know his kids like to go on big cat safari hunting trips for fun. But one of the pitches would be that he wants to drain the swamp and reduce the size of the bureaucracy, et cetera. Great. Citizen supervisions will help him do that, because one of the excuses the USDA always uses for why they don't enforce the statute more aggressively is they lack the resources. So, okay, great, you lack the resources. We want to bring those cases. You won't be involved at all. No resources required.
Thank you. Anybody else have an opinion on that or want to weigh in?
We've tried introducing the citizen suit provision in the past, and it's a hard one to explain to the non-lawyer as to why you need to create standing, and it's never gone anywhere. I would love to see a citizen suit provision. I'd like nothing more, but the reality of that just seems so far in the distance. And if President-elect Trump wants to do away with federal agencies, I hope the first one he'll look at is Wildlife Services.
Yes.
I wanted to talk, and there's a question here about the concept of haven standing or direct standing that Jenny mentioned, for anyone that wanted to weigh in about it. And to refresh people's memory from what Jenny said, there's a way that an organization could sue in its direct capacity by showing some diversion of resources and a frustration of the mission. Okay? And so I was wondering, to start with Jenny, but others should talk, I mean, what is the effect and how powerful is haven standing in animal litigation right now? And even more specifically, I mean, is haven standing doctrinally sound? Is it a real thing, right? I mean, it seems to me, thinking of it this way, that when we're talking about frustration of mission or frustration of purpose, we get very close to what's not allowed as Article 3 standing, some sort of conflict with your ideology. And then the other prong of the test is diversion of resources. But to use PETA as an example, I think PETA would openly admit that it's very fond of publicity. And to say that you're diverting resources to get press about something or to educate the public on something, wasn't that what you're always doing? You're always looking for a hook to get press and to re-educate or to educate further. And so how do you distinguish what you're doing from just an ideological injury, and how does that fit into haven standing?
I'll tell you, it's scary. You've obviously read briefs. These are the arguments we get in response. A diversion of resources isn't a diversion. It was a voluntary expenditure. Your mission is not frustrated. Your mission is addressing animal cruelty. So what if it's birds? And that means you're not doing primates. You're fulfilling your mission. And I don't know that we've been lucky. I think we've been smart in the way that we are framing our harms, and we're identifying the things that resonate with courts. But I have to admit that I cross my fingers every time, and I hope that none of us are going to break haven standing, because it's that important to the movement. And especially in the birds appeal, if you listen to that oral argument, poor Matthew Strugar spent so much time defending this unexpected argument about standing, and a judge wrote separately, and she basically said, if the precedent weren't already there, I would not give you standing. So courts don't love haven standing like we do, and that really feeds kind of Joyce's interpretation of what standing is. It's the way to keep unpopular plaintiffs out of court. But I think it is very much legitimate because we are harmed. There is so much animal cruelty, and with all of PETA's resources, we do have to pick and choose. It breaks my heart how many exhibitors I'm not currently focusing on. We could have sued over rubber stamping in every circuit, and we have to kind of choose one at a time. And we do have to educate the public, because they think that having an AWA license means you're actually compliant. In fact, an administrative law judge recently said that and was corrected, on appeal. But people do have this misperception that licensure equals compliance. And so it is a legitimate harm. We would rather, if we did it once and it stuck, then we wouldn't be wasting our money. But when you have to repeatedly send the same message, when you have to repeatedly go back to the same zoo, when you're seeing the same animals suffering over and over, that is a diversion of your resources. You would much rather be doing something else. We've also talked about donor fatigue. They get tired of hearing about Lolita. Tony the tiger we didn't talk about, but my God, the donors, you told them you won, or you told them you're working on it. It's 10 years later, you're still working on it. It does cost you money, and you can't just abandon your campaign. You've worked on it. So it's a legitimate harm. Just courts are uncomfortable with it, and we all have to be very careful with when we choose to use it and how we frame it.
That's a really good answer. Anyway, do we have time for? Should we? I think the railroad needs to stop here. Thank you very much for a great panel, and.